The use and misuse of Section 124A of the Indian Penal Code, IPC, which deals with sedition, has always been a subject of public debate and discourse. But despite many arguments against it, the Law Commission of India strongly backs the sedition law, recommending it even to be retained with changes linked to the circumstances of its use. Also, the Law Commission recommends that the punishment for sedition be increased from 3 years jail term to a life term or up to 7 years of imprisonment. The Law Commission report states that repealing the sedition law altogether can have serious adverse ramifications for the security and integrity of India. Last year, after the former Chief Justice of India, N.V. Ramana, expressed concerns about the misuse of the sedition law, the Government of India had said that it would take a relook at what has been described only as the colonial provision in India's penal code. The government then asked the Law Commission to review the sedition law after it was challenged before the Supreme Court of India. There are many instances of sedition charges being slapped against intellectuals, human rights activists, filmmakers, teachers, students and journalists, of course. Ashok, straight off the bat, I have to ask you, the discussion can swing between two extremes. Let's cut out the extremes first. Is there a need for a sedition law, an idea that was essentially mooted during the colonial era today?
Well, it's my personal opinion that basically sedition law is actually working as an unnecessary impediment on your freedom of speech, the freedom of speech of the citizens of this country. And the other reason why I believe the sedition law should be struck down of the statute book is the fact that, number one, it's misapplied, it's misused, abused by the authorities. The political party which comes to power weaponize this law.
Whichever political party comes to power.
Whichever political party. It's not about BJP, it's not about Congress, it's not about AIADMK or it's not about any other political party in Jharkhand, because I'll give you instances where these laws have been abused or misused. The third question is, the third reason that I believe that sedition law should be struck down is the fact that the law has been framed or has been put in such an ambiguous manner, or the language of the law is such ambiguous that there can never be a certainty. For the last 75 years, we have been trying to figure out a way as to what really constitutes sedition and what does not constitute sedition.
Right.
So, if a law is so shrouded in ambiguity, it either be struck down or either you simplify it.
Right. And I want to, before we go to the case, I want to understand your thoughts on the, the Law Commission, the process it went through, because, you have the Supreme Court of India asking the Government of India and the government asking the Law Commission, and the Law Commission eventually coming back and making a few changes, making the punishments harsher and also all the changes. I want your view on what do you make of the changes that were made?
Well, as far as the Law Commission is concerned, the Law Commission is basically a recommendatory body. It's an advisory body.
Fair enough.
Their recommendations do not carry any weight. They can be rejected by the Government of India, they can be accepted. So, there is no power behind the recommendation of the Law Commission of India. It's just an advisory body.
But what do you think of the advice it's given?
I think that it's not a measured advice that has been given by the Law Commission. The Law Commission basically says that just because a law is misused, it cannot be a ground of it cannot be a ground for striking it down. Well, that's a correct position, because even in the past the courts have held just because that there is a law which is being misused, you cannot ask for erasing the law because it's been misused. The second thing which I find a little troubling or cause of concern is the Law Commission of India making a positive recommendation and saying that this law on sedition is required to deal with people who have separatist tendencies. Now, as a country, if you look at India, you have militancy in the northeast, you have militancy in Jammu and Kashmir, you have the Naxal movement which spreads to a couple of states.
From central India onwards.
Onwards to the southern India. then you have people
There's talk of secession in Tamil Nadu.
secession in Tamil Nadu. Now, this particular law has been acting as unnecessary fetter on the freedom of speech. If people today speak something against the Prime Minister of the country or the Chief Minister of a particular state, the cops do the first thing is to slap a case of sedition against you, which is extremely funny, weird, and not acceptable.
Mr. K.C. Mittal, look at these cases. Kudankulam, 10,000 cases of sedition charged on protesters. Jharkhand, Pathalgudi, 7,000 cases of sedition charged against protesters, essentially. This law is being misused at an incredibly huge proportions, and hence that simple argument that just because a law gets misused doesn't mean it can't be struck down does not hold in this particular case. Would you agree?
I substantially agree with Mr. Ashok and the way he has highlighted the whole issue. Let me just add few things to you. Misuse is one thing. And unfortunately, in this country, what we are noticing is you bring a law, before the law is enacted and put in force, the misuse process starts. This is what you pick up any subject. We see notice every day in the courts. Every law is being misused. Quota was being misused. Mokoka, of course. Then you see ED, TMLA, which is not being misused. It is there. Let's go to another fundamental issue. See, when was this law enacted? This was put in force to suppress the freedom of struggle. That was a totally different environment, and the government had brought in this law purposely to suppress the freedom of struggle. Today, that is not the situation. Why do we need this law at all? See, and that's where the Supreme Court has also taken note of it. That's why three-judge bench has put it in abeyance. Let me tell you 3-4 important aspects. And Mr. Lekhi also pointed out one. It should not be to curb the political dissent. That's one important aspect. It should not have chilling effect on the freedom of expression, which it has nowadays. Law Commission says enhance the punishment. You are making it more draconian. How can you have it? The existing law itself is not required in the given situation. Today, this colonial system, the law must be either repealed or, if at all, it should be used only in grave situation that might arise. What is happening today? You can't just put anybody and everybody behind bars and use this law. This is what is happening in UAPA also. People are just put behind the bars and there is no remedy available to them. They don't even get bail. The purpose is not that. The purpose is, in a genuine case, if there is anything, one can understand. And I think my friend Ashok has rightly pointed out and given some instances. The whole aspect has to be seen from a different perspective. What the three-judge bench of the Supreme Court has observed while putting the law in abeyance. And I think ultimately the Supreme Court is going to strike a balance. Maybe. Because that's what one can read the order of the Supreme
All right,
Court.
fair enough.